Hi, I'm Allan with Greenberg, Traurig in Houston, and I'm here today to interview Harry Reasoner, former chair of the section of Antitrust Law and former managing partner of Vinson and Elkins in Houston, Texas. Harry, thank you for coming this morning.
Glad to be here.
Harry, you were born in San Marcos, Texas in 1939. What was San Marcos like at the end of the Depression and the war years?
San Marcos was a small town in central Texas, agricultural area. Had a state teachers college. San Marcos was about 5,000. The college was about 2,500, so it was dominated by the college. I actually grew up on a farm 5 miles to the north of San Marcos.
San Marcos, as the site of Southwest Texas State, was the alma mater of Lyndon Johnson, and Robert Cairo talks about farm boys and girls such as you having chores in those days that were pretty tough. What were some of yours?
Well, ours was not a productive farm. My mother taught school, and my father and his brother were auto mechanics, had a garage, Hudson garage. But we did have cows and chickens, gardens, so I milked cows, cleaned out chicken houses to fertilize the garden. An excellent preparation for the practice of law.
You know, as you know, Harry, I lived in San Marcos, and my father-in-law told me that your father had the cleanest garage he'd ever seen and was unquestionably the most honest person he'd ever know.
I don't remember you telling me that, but I'm delighted to hear it.
What lessons did you take from him that helped you in your career?
My father was a person of great integrity. He believed that you should do whatever you were doing as well as you could do it, and integrity and honesty were cardinal virtues of his.
And what did your mother teach?
My mother taught in the elementary school. She taught first grade, and then in the summers she taught reading, or how to teach reading. At the college, she never took opportunities to go into administrative positions because she always felt that if she could teach a child to read well, she could make them a good student for the rest of their lives.
How did you get interested in economics?
I went to undergraduate school at Rice and had a couple of really outstanding economics professors who interested me in it. Then I went on, after I went to the University of Texas School of Law. I spent a year at the London School of Economics, where I studied comparative law of competition and monopoly, but I took some economics there. Basil Yamey was my tutor, so I think I was much influenced by the quality of the people I was exposed to, but I found it to be a fascinating study.
Did you study antitrust law at the University of Texas?
I did, although we had a marginal antitrust professor. I really became more deeply interested in it at the LSE, where I had a seminar with Professor Robert Stevens, who was visiting from Yale, who was an outstanding instructor.
Now, you took Texas civil procedure from the immortal Gus Hodges, did you not?
Yes, my father-in-law was a professor at the University of Texas Law School and the leading authority on civil procedure. I became his student assistant, which was awkward because I started dating his daughter and was behind in my work when I would show up to pick her up for a date.
And after completing your studies at the University of Texas and LSE, you clerked for Judge Clark on the Second Circuit?
Yes, Judge Charles Clark, who had been dean at Yale. Macy and I had gotten married. She was going to transfer to Yale Law School, but got pregnant, and so didn't. She had gone her first year at the University of Texas. In that time, judges just had one clerk. Judge Clark had spent a lifetime in teaching, perhaps best known as the author of the Federal Rules. But it was a wonderful experience. I sometimes felt like I was his only student. I was his only law clerk who hadn't been from Yale Law School, so he was worried about us being lonely, so we went to dinner with him every Sunday, and I took Judge Clark to the symphony, many events. It was a wonderful experience. I had gotten the clerkship, I think, because one of my professors at Texas, whom I had been very close to, was Charles Allan Wright, who had been Judge Clark's clerk, and suggested to Judge Clark that he give me a clerkship.
And after your clerkship, you returned to Texas?
I did. We had, Judge Clark had recommended me for a clerkship on the Supreme Court, but with Macy pregnant, we really didn't think we were up to having a child and trying to figure out how to live in Washington. So we returned to Houston to Vinson and Elkins.
And you went to work with David Searles, who had been chair of this section in 1953-54.
I did. Mr. Searles, I think, was the second chair of the Antitrust section and instrumental in its founding. When I started work, I really wasn't sure what kind of practice I wanted. I was fascinated with antitrust, but also taxation. It seemed to me taxes have the most to do with shaping the American economy, with the incentives and disincentives they give. And so they told me I could spend 6 months in tax and then 6 months litigation and see what I preferred. But when I arrived, Mr. Searles said he had an antitrust case that was going to trial, and he was then the senior partner in the firm. So I started in antitrust, and I never got around to trying tax other than litigating a few tax cases.
I recall you're telling me about one of your early cases involving Retail Credit Company and a humorous, I guess it wasn't humorous at the time, but event during the deposition of the company CEO.
We were trying, a case before Chief Judge Singleton, who was a rather salty judge. This was during an era when credit companies had come under considerable opprobrium for probing into personal matters, for fostering improper collection practices, and this was a fight between two credit companies. Judge Singleton remarked he felt like he was presiding over two prostitutes struggling in a gutter. But we were doing well, I thought. It was a monopolization case, attempted monopolization case. Today it would be dismissed on the pleadings under current standards. But in that era, we went to trial. I thought we were doing well until our CEO was asked, well, now, did you have intent to harm the plaintiff? He said, no more than an elephant has intent to harm an ant it steps on the way to the water hole. As you might suspect, we ultimately lost that case. But I was, I think, for me, fortunate to practice antitrust in an area where it was very different standard. I started in the 60s, an era where Justice Potter Stewart said the only theme to antitrust cases was that the government always wins. But Vinson Elkins did a great deal of energy work in that era, and the energy industry was a frequent target of antitrust litigation. So when I started with Mr. Searles, we went to trial in 4 major antitrust cases in the first 5 years I was there. Ironically, reading the current FTC investigations, the antitrust market in New Mexico, we tried a case against the government over a small refinery acquisition by Conoco in New Mexico. Represented Sinclair in the Arco Sinclair merger, which was tried in the Southern District of New York. Had the great good fortune to work with Hugh Cox of Hovington Burling, one of the greatest lawyers I've ever met, in an attempt to enjoin a hostile takeover by American General Insurance Company of the American Casualty Company. Tried that in the District of Columbia, and tried a state court conspiracy case. So at the time, I had no idea how lucky I was to get that much immediate experience.
You know, the first case that you and I worked on that I can remember involved the worldwide uranium cartel, which came to justice in state court in Santa Fe, New Mexico.
Well, yes, I thought that was a wonderful experience for all of us, you and me, Paige Austin, I guess Max Hendrick. There was in Chicago multi-district federal litigation. Our plaintiff was somewhat unusual in that they were a uranium producer rather than a purchaser. And our argument was that the activities of the cartel had driven up the price and cost, made their production long-term contracts unprofitable. We filed it in state court in New Mexico, one, because that was our client's headquarters, two, because we didn't want to be caught up in the federal multi-district activity, which is we had expected ground on indecisively for years. But as you recall, we settled on the eve of trial, but it did seem to me the state courts of New Mexico would have done justice. But the other thing that lesson from it is how difficult it is to deal with sophisticated international cartels. They, of course, had conducted most of their activity abroad, had kept their documents in areas that were not reachable by U.S. discovery processes. Federal grand jury had limited success. We, as you recall, relied heavily on the most effective discovery technique when the Friends of Earth broke into a company's headquarters in Australia and stole their files, which happily were authenticated by the California Public Utility Commission. I guess the other lesson that stuck with me on that, as you recall, the critical discovery we may ultimately got from one of the conspirators, Gulf, was by getting orders to take the depositions and search the files of their legal department. That would occur again in other cases where we're plaintiffs.
In addition to yourself, there were some other colorful characters involved in that case. One was the CEO of our co-plaintiff, Ranchers.
Yes, Maxie Anderson, who set the transatlantic record for crossing it in a balloon.
And of course you remember our co-counsel in Santa Fe.
Yes, Ann Bingaman, later head of the Antitrust Division in New Mexico, not irrelevant that her husband was then Attorney General of the state, as I recall. Ann had done an absolutely splendid job in working on a parallel case and joined us, but she had done Ann had done fantastic work in digging out documents from the cartel and pushing them endlessly in motions to compel and activities in the state courts.
Let me change topics a little bit and ask you about the work that you did with the ABA Antitrust section leading up to your election as chair.
Well, because Mr. Searles, I think, had been active in the section since its formation, he had strong feelings about how valuable it was for people practicing the antitrust area. So he encouraged us, encouraged me and other young lawyers at Vinson Elkins to participate fully in it from the outset of our careers. It turned out to be, I think, has been one of the most rewarding experiences I've had professionally. Through it, Macy and I have made many lifelong friends. The substantive learning value is enormous, and working on its committees, I was chair of the economics committee, were wonderful experiences, both the intellectual discourse, the ability to discuss topics not in an adversarial way, but where all of the parties involved are genuinely seeking to learn. It's been a wonderful experience and gave me the opportunity to get to know some of the really great lawyers in America.
Now, the year that you became chair of the section also saw you in perhaps the largest antitrust case of your career.
Yeah, well, it certainly was the largest judgment. That was actually I tried the Etsy case, as you recall, having participated in it, in March of '89. That was a case where we sued 6 railroads for conspiring to block the construction of a coal slurry pipeline from the Powder River Basin of Wyoming to Texas in the south. Coal slurry lines where you grind coal to the consistency of talcum powder, and then you can actually pump it like oil. Clearly workable technology. The Santa Fe Railroad itself ran one in the west successfully for years. The railroads, through a long history of refusing right-of-way crossings when they had no right to, filing sham litigation, bribing Indian tribes to protest the pipeline, etc., successfully destroyed the pipeline. They paid hundreds of millions in settlement, the last after we got a $1 billion judgment against the Santa Fe. But sadly, as is often the case in antitrust activity, that was an entirely rational exercise from them, since there are now 2 railroads hauling coal from the Powder River Basin, and for both of them it is an enormous source of their profits. And the consumer utilities are paying monopoly rates. Railroad transportation from the Powder River Basin costs more than the price of the coal.
And no brag, just fact, but that $1 billion judgment was the largest plaintiff's antitrust judgment at the time.
Yes, I think that's right, although I think it's probably been exceeded since.
And before it settled, in defending that judgment on an appeal, you had quite an illustrious team working with you.
Well, we did. I had long been friends with Professor Charles Allan Wright, the great federal courts constitutional scholar, and so we got him involved working on the brief with us. Charlie could write like an angel, one of the best I've ever seen.
And of course, the case itself involved the constitutional principles that underlie the Noor-Pennington Doctrine, which was central to the case.
It did, and it involved constitutional principles, and so we thought Charlie would be valuable. The other, of course, was our great friend Phil Arita. I had gotten to know Phil. I taught antitrust as a visiting professor at the University of Texas School of Law in the summer of 1971, and in preparation for it I had read Professor Arita's textbook from cover to cover, and I guess from long habit, as I read it, I noted typographical errors. So I wrote Phil and said how wonderful I thought his book was, and I was going to teach from it, and that I was sure there would be many additions, and I thought he would appreciate having this list of typographical errors. He wrote me back a warm letter, and we were then saw each other on CLE programs, and I talked to him about, he was then giving some CLE lectures sponsored by a commercial CLE provider. So I asked him about it, how much he got out of it, etc. And I said, well, hell, I can have paralegals do this for you. You can come give one in Houston. You can keep all the money. So then I suppose for a decade or so, Professor Arita would come and give a one-day lecture for 8 hours. Probably the only man who ever lived who could hold an audience enraptured talking about antitrust for 8 hours. But we became very close, and Macy and Phil and I traveled a lot together, particularly to Europe. He was a great connoisseur of wines, and food. In fact, the large bequest he made to Harvard, I think a big portion of it was the value of his wine cellar.
Harry, you're best known for your antitrust work, but you have been involved in some very significant pro bono cases, from reforming the Texas prison system to defending the University of Texas's use of affirmative action in law school admission. Why has pro bono been important to you in your career?
Well, I think for all, I think it's important to me for the traditional reasons you hear in the profession. I think it is one of the things that makes our profession more than a commercial trade. But I do feel I felt personally it's important to feel like you're trying to give back something to society and to profession, which has been very rewarding. And pro bono trials are a wonderful thing for all lawyers, in that the experience they give you in litigation is fascinating. I had tried a number of criminal cases for the experience on an appointed basis, but the Texan prison case, the Guajardo case, I was appointed by the chief judge. The Texas prison system was, well, I started to say medieval, but that might insult some medieval prisons. They were under budgeted, had prisoners in charge of other prisoners, which led to brutal treatment, sexual mistreatment. They gave them no First Amendment rights, censored the mail they wrote to their lawyers, wouldn't let them write to the media. So we filed a class action under the Civil Rights Act. We litigated it for over a decade. I had to try it 3 times. We prevailed each time, but then the prison would attempt some other way to avoid oversight. Then for years, under the injunctive decree we had entered, our lawyers would volunteer and act, represent prisoners who claimed there were violations of the decree, and often that involved no more than kind of moderating disputes. But I think it played a great role in reforming the prison system. Unfortunately, the Congress passed a statute limiting the jurisdiction of federal courts to oversee prisons, which led to the dismissal, vacation of our decree and the dismissal of a case. In Texas, and I suspect around the nation, barbaric conditions have returned at many of our prisoners. Texas, I know, suffers from massive overcrowding, deficiencies in the number of guards. I believe that's largely true throughout the country.
What was your reaction when your alma mater, the University of Texas, asked you to lead the defense of their use of affirmative action to try to get more African American and Hispanic students into their school?
Well, I believe that it is critical. An open education system has been, I think, the genius of American society, and it is, I think, critical for minorities to have access to our great schools. And then I think students who, majority, Caucasians are majority for the moment in Texas, the majority who go to segregated schools, I think, suffer from having a limited experience, that it doesn't resemble the society they'll practice in. I think it's particularly true of law, where I think it's essential for a person to have a broad understanding of society. So I believe very strongly in the cause. I also believe it was very important for the University of Texas to be represented by a major law firm. In this peculiar instance, the Attorney General of the state of Texas, Dan Morales, was opposed to affirmative action. But beyond that, I thought it was important to demonstrate that, that an institution which was in the establishment of the state believed in defending the University of Texas on this matter. So I was delighted to do it. As you know, having tried it with me, it was, I thought, a great experience to try it. I thought we got, of course, when we won in the trial court.
I was going to say, history probably doesn't note that you actually won that at the district court level.
Yes, and you know, we made an extensive record. Texas was a state where the majority of the public school districts were still de facto or de jure segregated. Their own expert, the Harvard professor, admitted that children whose parents had gone to segregated schools suffered from it, admitted that the largest factor, predictive factor in how students will do in college comes from their parents' background. I thought we would lose on appeal when we got when we saw the panel. There were people good judges who felt very strongly the other way.
And you argued the case against Ted Olson, who would go on to be Solicitor General.
Yes, Ted made a great argument, as you would suspect. I think my guess is even Ted was surprised when the Fifth Circuit panel held that they could read the tea leaves that Sandra Day O'Connor had overruled, had prohibited affirmative action in higher education, and of course ultimately turned out the Fifth Circuit was wrong in its prediction. I also felt a key fact was that they artificially cabined the inquiry, not looking. We, unlike the Michigan case, also had the argument that affirmative action was needed to overcome the historical effects of racial discrimination, and the Fifth Circuit looked at the law school in isolation, did not look at the educational system that produced close to 90% or 80%, I suppose, of its admittees at the time. So while it was, I think, the most painful loss I've ever been involved in, I'm very glad we did it.
In seeking certiorari, you not only called on your old friend, Professor Wright, but a new friend, Professor Traurig.
Well, yes, actually I had gotten to be good friends with Larry in the Pennzoil Texaco litigation. I've always thought we were hamstrung in a petition for cert because the day the petition for cert was filed, Attorney General Morales stood on the steps of the Attorney General's office building and said he thought affirmative action was illegal and immoral, a statement that Ted made excellent use of in his opposition.
And without naming names, I can confirm that one Supreme Court justice told us that they did not believe that Texas would put up the good fight and so would not grant cert on that case. You mentioned Michigan was involved in the case. Lee Bollinger was a witness for us, and for
Yes.
his good work got his own institution sued. But in the end, I guess that suit vindicated your position.
Well, it vindicated our position. I thought Justice O'Connor wrote a brilliant and very realistic and honest opinion. Of course, with the wave of referenda, Michigan now will have a terrible time. I think race and racial discrimination remains one of the greatest problems of our country, and to me, saying we have a colorblind country is kidding ourselves.
Harry, looking back, do you have any concluding thoughts or advice for the young lawyers who'll be watching this tape?
Well, I would say seize the day and enjoy the moment. Cases you win, cases you lose will pass, but enjoy the process. I think can be a great and intellectually stimulating profession, can be great fun. On the other hand, you need to have a life. Don't give it up for the law.
Thank you, Harry.